An interesting case illustrates some of the landlord and lessee problems that are encountered. This is a class in torts, yet we study this case. Klein versus 1500 Massachusetts Avenue, and of course the proper citation. And always, when talking about a case, give the proper citation. Citation tells us where to find the case, and without it, we're lost. This is the United States Court of Appeals, District of Columbia case, circuit of 1970. It can be found at 141 U.S. App, DC 370, and also 439 Federal 2nd 477. Remember, the first set of numbers refers to the volumes. The last set of numbers refers to the page. The tenant in this particular case was criminally assaulted and robbed while in the common hallway of a large office apartment building. And yet this is a criminal case that we're discussing in torts. Why? Because the court said a duty exists such as innkeeper and guest, landowner and invitee, businessman and patron, employer, employee, school district pupil, hospital patient, and carrier passenger. What we're saying is there is a special duty in such a case. As between the tenant and the landlord is the only one in position to take the necessary acts of protection required. He is not an insurer, but he is obligated to minimize the risk to his tenants. His duty is to take those measures of protection which are within his power and capacity to take, and which can reasonably be expected to mitigate the risk of intruders assaulting and robbing tenants. So the landlord in this particular case could be liable in a tort. Be careful and always observe, always look for special relationships as above noted. Otherwise, we have no duty to warn or to rescue. There is no obligation to aid or assist others. However, remember, once assistance is started, it must continue. Thank you for your attention and understanding.